Welcome to On the Ballot with Ballotpedia, where we take a closer look at the top political stories of the day. Ballotpedia connects people to politics by providing neutral, nonpartisan, and reliable information on our government, how it works, and where it's headed. I'm Victoria Rose. Thanks for being with us. Today, we're joined by Robert Michos, who's a professor at Vanderbilt's Law School. Robert is considered one of the country's foremost experts on drug policy and federalism. His research in recent years has focused on marijuana legalization and the landscape that's developed over the last 25 years, exploring the complicated relationship between federal, state, and local governments. He's also studied marijuana's path from an illegal substance to medicinal to the patchwork system we have today as a way to better understand the drug policy developments that might be on the horizon for psychedelics. Rob, thanks for joining us today.
Thanks for having me.
Since we're going to talk a little bit about federalism, and our listeners may have forgotten what that term means since they studied it in high school, I was wondering if you could give us a quick overview.
Federalism, to simplify just a bit, it's all about the relationship among these different levels of government. It's the relationship between the national government and the states, most prominently, but also the relationship among the different states in our country. Things like, are there some things that are reserved just for the states, some for the national government? And when they do share that responsibility, it involves some rules about how they're supposed to respect each other's laws, that sort of thing. So simply put, federalism is about those relationships, the relationships among different levels of government.
And what made you want to make this a core research area for you, especially in regards to drug law?
Initially, I was interested in law school by federalism. I had a common law professor in my very first semester, Evan Kamenker at the University of Michigan Law School, who was great and just kind of explained to us and showed us why federalism, and it's not only really interesting, but also has really important ramifications. It's part of battles we've seen fought over all sorts of policy domains, slavery and civil rights in past areas to drug law today. I was interested from an early date in law school in federalism. And then when I became a legal scholar, I focused on federalism. Honestly, I had no interest whatsoever in drug law. Personally, or at an academic level, I could care less about marijuana. But when I was getting started, it just so happened that there was a big case, a federalism case coming up before the Supreme Court. It just so happened to involve medical marijuana. It's this famous decision, Gonzalez versus Raich, where the court was trying to decide, does Congress have the power to regulate intrastate activities involving marijuana? Could it regulate, for example, the growing of marijuana in your backyard if you were a medical marijuana patient in California? And that got me interested. It happened to involve medical marijuana. The court ultimately answered in the affirmative. It said Congress's commerce powers are really expansive. To regulate the growing of marijuana in your backyard, even if you're not going to sell it, even if it takes place entirely within the state. And there were all these really gloomy prognostications about the demise of federalism. People said, hey, court just killed federalism by affirming this broad congressional power. They also said, hey, you just killed all these medical marijuana laws. There were just a few at the time, but lots of gloomy prognostications about that. I was in California at the time, and I saw on the ground that all these gloomy prognostications were wrong. The day after the Raich decision was handed down, things were no different on the ground in California than they were beforehand. The people were still growing and trading and selling medical marijuana openly. There were more states in the coming years that passed ballot initiatives to legalize medical marijuana. So this is really one of my first projects. I sought to explain, what did all these gloomy prognostications miss about federalism? What didn't they understand? Why were the states still doing this, and how are they getting away with this? So it was just by accident that I stumbled into this area. I thought it'd be a one-off thing and I'd move off to some other federalism project, but I quickly discovered that there's no shortage of really cutting-edge, interesting issues that are created by these medical and now adult use marijuana laws and these other state drug law reforms. So I've stuck with it ever since.
The federalism question surrounding marijuana law has a lot to do, obviously, with the classification of marijuana at the federal level. And like you were saying, there's always something going on with this policy. Just this past week, we had the Health and Human Services announce or recommend on August 30th to move marijuana from a Schedule 1 drug to Schedule 3 drug. So does that recommendation have any force, or could the DEA, the Drug Enforcement Administration, choose to ignore it? Where does that leave marijuana?
Yeah, it's a great question. So that spin on it is really a federalism question, but it's another area of law, which is more administrative law. So Congress, when it passed the Controlled Substances Act, that's the key federal statute here, they created this scheduling system. Scheduling determines how a drug is regulated. It gave two different federal agencies, so Health and Human Services and the Drug Enforcement Administration. It gave them power to move drugs around on those schedules. So if we discovered that a drug has some medical benefits, you can move it off of Schedule 1, put it on one of the other lower schedules, and allow it for medical use. So that's what's going on right now, that the HHS has initiated that process of reviewing the scheduling of marijuana. Historically, it was placed when the CSA was passed on Schedule 1. That's the most tightly controlled substances. They're pretty much always banned except for use in clinical trials. So HHS has recommended that the drug be moved to Schedule 3, which is where you see other legal drugs. We don't have a lot of details yet about how the HHS reached that conclusion, but it necessarily means that agency, like for the first time in the federal government's history, that agency has decided marijuana has some demonstrated medical value to this drug, but we haven't yet rescheduled marijuana. And so HHS has just kicked off this process. Now the ball is in DEA's court. And interestingly, the statute, Congress kind of wisely said, well, the DEA, you're not a scientific agency. You have to respect and abide by the scientific judgments made by HHS. So if HHS says there's medical value to marijuana, you're stuck with that. But there are some other, I call them kind of legal factors that the DEA gets to consider that likewise are outside the purview of HHS. Maybe most notably there, Congress, interestingly, instructed these agencies that when you reschedule a drug, you have to obey U.S. treaty obligations. And the United States is a party to a bunch of different international drug control treaties. You can allow its medical use. The prevailing wisdom right now is that the treaties would only allow the United States to move marijuana to Schedule 2 rather than Schedule 3, which is not quite as tightly controlled. So HHS might say, based on science, we could get ones in Schedule 3, but you might see months down the road or years down the road when the DEA makes its determination that we can only move it to Schedule 2. But I think it is notable that I think it suggests at some point in the next couple of years, we probably will see the federal government move this drug off of Schedule 1.
Yeah, I didn't know all the nuances around the international treaties. That makes it very interesting as far as what this all could mean. So that's at the federal level. Let's turn our attention to the state level. Today, recreational marijuana use is legal in 23 states and Washington, D.C., and then it's legal for medicinal purposes in 38 states. And this began in 1996 with California. How have ballot measures and direct democracy factored into legalization efforts across the country?
They've been huge. In fact, the very first reforms, it all started as medical. So that was California, that was Oregon, that was Alaska, Washington State, and so on. And I think there's a reason for that. I think state legislators, even today, they're still skittish about liberalizing drug laws. And in states that have ballot initiative processes, that gives you a way to get around those state legislators. They're dragging their feet. And so that's what voters did in California and elsewhere. And really, they got this movement underway. And I would say most medical marijuana laws, most adult use reforms still to this day have been passed via the initiative process. And the places where, the few states now that haven't adopted even medical marijuana reforms, these are states, not surprisingly, that don't have a real ballot initiative process. So if you're stuck with your state legislature and you can't go around them,
And do you think like Oklahoma voted on marijuana recreational legalization earlier this year and it was defeated? And that happened in Arizona as well in 2016, but then ultimately they passed it in 2020. So do you think in states where it is defeated maybe on the first go around, public opinion will change over time and it'll get legalized further down the road?
I do. We've seen kind of public opinion move in one direction, favoring more and more liberal marijuana policies. Even in states, like you say, that failed to pass on the first attempt. California was the same thing happened. Well, California failed to pass adult use legalization. It was shut down, but then later adopted it. So I think given more time, that's likely to happen. Sometimes there are peculiar reasons why voters reject a ballot initiative. Sometimes they might feel, hey, this has been hijacked by some party. It's ostensibly about legalized marijuana, but it's really about making some group of investors rich, and they don't like that. So that's one problem you can encounter.
Being a ballot measure person or a person interested in ballot measures, we've also seen local governments or local initiatives to decriminalize marijuana at the local level in states where it is illegal. How does that factor into who is going to enforce marijuana penalties?
That gets a little bit trickier. So that's really an issue of localism. And it's very similar in some respects to federalism. So the case for federalism and keeping the states around and empowering the states, it's oftentimes that we let them each do their own thing. More people are going to be happy with the outcome than if we have a one-size-fits-all solution imposed by Congress. Well, you could take that down within the states and say, within Tennessee, people in Nashville want a different policy than do people in Memphis or maybe people in Clarksville or other parts of the state. And so that's why local governments, in some respects, they're saying, hey, we should be able to do the same thing that states have done. We don't like, the next level up policy. If you don't like prohibition at state level, we'll legalize it locally. The problem that local governments have run into, though, is they don't have quite the same legal power vis-a-vis states that the states do vis-a-vis the national government. Just every locality, every city, county, and so on, you say they're creatures of the state. And so the state can boss them around a little bit more. And so sometimes you'll see local governments say, hey, we want to decriminalize simple possession of marijuana, even though it's a crime at the state level. But as a practical matter, those tend to have a little bit less of an effect than if the state said they were going to decriminalize this possession of this drug.
And there's another level to this that we're watching this election year. In North Carolina, the Eastern Band of Cherokee Indians are voting on a ballot measure to legalize recreational marijuana. They already have legalized medicinal marijuana in 2021. So there's just so many layers of governments at play here. It's very interesting.
The tribal angle is interesting. We've seen that play out in other policy domains, like gambling is a big one, sales of cigarettes, what taxes you impose on that. So having all these different enclaves and all these different levels of government, it helps people get what they want. You can keep taking another bite of the apple and say, well, my state didn't support this, I'll go to your tribe, or I'll go to my local government, and so on. Although it does make to this kind of weird hodgepodge, patchwork quilt of policies.
You kind of touched on this earlier when you were explaining why you got into federalism and drug policy to begin with. But what are some of the other marquee legal conflicts that have taken place over the last 25 years, besides Gonzalez v. Raich, that are notable for our listeners?
I'll point out a couple of these. One is immigration, and I've worked a lot in that field as well. There's a lot of dissatisfaction with federal immigration policy, federal immigration enforcement. So you see some states like California that try to become sanctuary states and say, we're not going to help the federal government remove certain aliens who are in the country, even though they're undocumented. Then you see other states like Texas taking a very different position, saying, hey, we're dissatisfied with the lack of federal enforcement. So we're going to step up and try to enforce those immigration laws ourselves. Another one that is relevant to the marijuana field is sports gambling. There was a ballot initiative. Again, this oftentimes starts with a ballot initiative in New Jersey about a decade ago that's in kind of a backhanded way tried to legalize sports gambling. But you had a federal law in the books, this obscure Amateur Sports Protection Act that declared that the states weren't allowed to do this. The states weren't allowed, other than grandfathering in Nevada, states weren't allowed to legalize sports gambling. New Jersey wanted this to try to boost the fortunes of its casinos and racetracks. So there was a legal dispute. A bunch of sports leagues sued New Jersey saying you can't legalize sports gambling. It's bad. It's illegal under this federal law. But New Jersey prevailed before the U.S. Supreme Court. It was a case called Murphy versus NCAA, where the court said, Congress, you can't stop a state from doing this. You can't stop a state from legalizing some activity just because you don't like it. The federal government, if it wanted to, could step in and pass a federal ban. But you can't force the states to regulate some activity the way that you want them to. And that is why today sports gambling has become ubiquitous. It's just a few years ago, there was a U.S. Supreme Court case that said, Congress, you can't force the states to ban this. There's no federal ban on the books. So all of a sudden, all these MGM and all these companies, DraftKings and so on, they say, hey, we're running with this. And states started to legalize it. That's another one it's a policy dispute about gambling and whether sports gambling is good. But there's a key federalist angle to it that a lot of people overlook that explains why we've got this sudden change in the law, why we have this service offered now that we didn't before.
Yeah, for sure. It's turned out to be some of the most expensive ballot measures in history. You've also researched and spoken about the Dormant Commerce Clause, which I guess to start, I should have you define, because that may be another jargony term that our listeners don't quite have a good grasp of. So could you define it and then also explain how it applies to the marijuana conflict?
Yeah, so it's a somewhat obscure legal doctrine. The idea behind it, it's not based on any specific text in the Constitution. It's loosely based on Congress's commerce power. It's given the power to regulate interstate commerce. But the courts have basically invented this and said, under the Constitution, the Dormant Commerce Clause blocks states so they can't discriminate against interstate commerce. So if you are in California, for example, you can't ban your grocery stores from selling Florida oranges just because you want more business for your California orange growers. So the Dormant Commerce Clause, it's a very powerful tool, doesn't require any congressional statute and so on. It just kicks in automatically. And this has become a huge issue in marijuana law because the states all blatantly discriminate against interstate commerce. So all of these 38 medical marijuana states, all of those 22 or 23 adult use marijuana states, they say you can go, certain people get a license from us to go ahead and cultivate and sell marijuana, but they all have to be based in state. And oftentimes they have to be owned by state residents. They can't bring in any product from outside the state, and they can't ship any product outside to another state. So Colorado will say, hey, you can grow and sell marijuana here, but you can't bring in any of that Oregon marijuana. And that, if this were any other product, this were oranges or blueberries or avocados or automobiles, clearly violate the Dormant Commerce. We know that. The states, though, they kind of assumed that it didn't apply because they said, well, the Commerce Clause isn't dormant, being used. Congress has passed the statute and it's banned all this interstate commerce. So Dormant Commerce Clause doesn't apply. That's why states thought they could get away with this. But there have been a number of legal challenges recently where federal courts of all places have said you're wrong. Just because Congress says it's fine to sell marijuana doesn't mean you're allowed to discriminate geographically against some people who want to sell it. But this has proven to be a big challenge for the states because they were operating under this assumption. They created these elaborate closed loop supply systems where all the marijuana that's sold in the state was going to get grown there. They would track it from seed to sale using these RFID chips. And that gave them a lot of power over the market. They could track everything. They could make sure it's not being diverted. They could make sure that people were paying their taxes and so on. Well, all of a sudden, if you have to allow product in from outside, they'll really complicate that monitoring system they've established. It might run a lot of these businesses out of the market. Why would you grow marijuana and don't want to pick on New Jersey, but New Jersey. Why grow it at some warehouse in New Jersey? We can grow it outdoors in Oregon. It's much cheaper. So it's going to cause a lot of chaos, I think, in the markets. It's going to cause a lot of headaches for state regulators and so on, trying to come to grips with this, especially if Congress doesn't step in, do something that kind of help regulate what will be a national market for marijuana.
It's in the state's interest for it to remain like a state issue as far as legalization goes. Whereas like if the federal government legalizes it, then it kind of complicates all of the regulatory schemes in these states.
Yeah, it's ironic. You think, hey, the states would love to have federal legalization, but even without federal legalization, this problem might arise. This courts have already said, hey, dormant commerce clause is already active. Congress does have the power to suspend the dormant commerce clause. So there have been some states that argue that's what Congress did when it banned marijuana and sale of marijuana. So if Congress legalizes the sale of marijuana, that argument clearly goes out the window. I think ideally that what the states would want is they'd say, we want federal legalization, but we also want Congress to pass another statute or another provision that authorizes us to discriminate in this market and to refuse interstate commerce. We don't want it. Congress has done that elsewhere. It's done that in the insurance market, for example, but you would need Congress to pass a new statute to get something like that. Otherwise, you're stuck with this old dormant commerce clause, and states are really going to be caught off guard if that gets in.
That's so interesting. Beyond marijuana, psychedelics has become a hot topic in the drug policy. So what sort of lessons can you extrapolate from your study of marijuana legalization that may find parallels in the psychedelic space?
I think there are a lot of lessons for it. One of them is that you're probably going to make a lot more headway if you go through the states rather than the national government. There are moves afoot to reschedule some psychedelics, but as we've learned from marijuana, that's really tough to do. You need a lot of science, you need a lot of money, patience with that. But in the meantime, you shouldn't necessarily forgo that altogether. You might have a lot more success with ballot measures, especially ballot measures. This is something that I think might be more popular among voters than among state legislators. So that's one thing. Go through the states rather than the national government. There are some limits to that, some problems you're still going to run into, and we saw that with marijuana. Initially, that first decade or so when states legalized medical marijuana, there was no market for it, no state license market, because the states feared the DOJ could step in here and shut down big license suppliers. So you may be forced to make compromises like that with psychedelics. That might be too steep a price to pay. But one lesson is go through the states, but be mindful of the constraints that federal law imposes on you at the same time. The other thing here is there's a reason I think all the states like California started with medical marijuana. It's just much more sympathetic, especially with the ballot initiative. You go to the people and the poster child for these is going to be 80-year-old terminally ill grandmother. So I think some states like Oregon has passed a ballot measure in the psychedelic space, legalizing psilocybin. It's a little bit coy about whether it was medical. It talked about the therapeutic value of psilocybin. Didn't actually require a doctor's visit in the same way that medical marijuana laws do. But I think framing it as medical, this is an easier political sell. And later, lots of people extol other virtues of psychedelics, opens your mind, changes your way of thinking and so on, that aren't traditionally medical. I think that could come later.
Before I let you go, let's look into the crystal ball. Do you see federal legalization as inevitable?
I do. We had this announcement from HHS talking about rescheduling, which would legalize it for some medical purposes, but clearly not adult use, not recreational use of marijuana. So I think the writing's on the wall. There's so much public support to this that eventually it's going to happen. I think the opponents are just going to get worn down. It's one of these things where the vast majority of people support it, but it's not a high priority issue. I think politicians realize that. They say, I'm not going to win the election if I do one thing or the other on this. So we're stuck with Congress. So it's going to happen. I'm confident at some point in the next 50 years.
Thank you for your time today and for sharing your expertise with us. This was a really great conversation. I enjoyed it. And for our listeners, you can check out Rob's work on federalism and drug policy at the link in our show notes. Make sure you subscribe to On the Ballot wherever you listen to podcasts. I'm Victoria Rose, and thanks for listening.